Hi, this is I'm on your side, Dr. Cora again. I just wanted to, um, I've had a bit of time to try and clarify my thinking on this, and it's like learning law from first principles. So let me just say what this is about. This YouTube video. It's for information purposes, and might be interesting for people who are interested in law or just current affairs or politics or what's going on at the moment, just to see would they agree or not agree with this. I find it logically, it makes logical sense to me, but it's not. It taken me a while now to clarify maybe some issues that weren't so clear up to now. But let's get see, we have the clarity now that that would be very hard to contradict, say perhaps that we mightn't have had before. So let me put it like this. When party power collides with the Constitution, statistical and constitutional proof of democratic suppression in Ireland's 2025 presidential nomination process. So this is by myself. So in September 2025, something unprecedented happened in Ireland's democracy. A single political directive appears to have transformed a constitutional nomination process into a party-controlled mechanism. Now, we all know that it was a Fine Gael-led directive, and that it was seen by RTE. So this is the first quantitative. Well, I've done another video on this, but I have applied some quantitative reasoning to this because of my mathematical probability background. So I mean it's we'll see what the mathematics tells us about this. So this is the first quantitative and constitutional analysis of that event. It's actually the second, but this is combining data, law, and the Irish Constitution itself. So it's the first one that combines them all to ask one question. Can a democracy remain free if party power overrides the people's constitution? In 2025, Fine Gael National Executive reportedly instructed its 246 local authority councillors to block independent candidates from receiving council nominations. Under Article 12 of Bunreacht na hÉireann, citizens may be nominated either by 20 Oireachtas members or by 4 local or city councils. So we say 4 local councils, they include county and city councils. There's 31 of those. By the constitutional deadline of the 24th of September 2025, not a single independent had achieved the required 4 council threshold, as we all know. Was this coincident or was it coordinate obstruction? This is the question. Now, obviously, is that a hypothesis? I think so. We could put that into a hypothesis, couldn't we, if we were anyway decent with statistics and see, what does the mathematics say? Are we going to say mathematics is of no value? Well, let's combine it with the law here and see what we get. I'm looking at the Constitution. Now, the Constitution, to me, looking at it, is like a set of axioms in mathematics. So it's very interesting from that point of view. So there are 5 articles from the democratic spine of the Republic, as I see it. Article 1 affirms national sovereignty. Now, a lot of people are reading my. I have translated the Irish Constitution into Word version, simplified version, and there's a lot of people from various places reading it, and I'm delighted because it reads very well. It's like a happy place. Nirvana. Anyway, or somewhere like that. So our Article 1 affirms national sovereignty. Article 6 declares that all powers derive from the people. This is in plain language, but I think it's a fairly good translation. Article 12 guarantees access to the presidency through 2 nomination routes. Article 13 protects institutional independence. Article 28 holds government accountable to the Constitution itself. That's very important now. The government is accountable to the Constitution itself. Together, they forbid any political body from nullifying a constitutional process through uncoordinated instruction. Now, by logical lack of urge to apply any kind of logic, any kind of event or any kind of action on behalf of a government party member that would violate any one of those would violate the Constitution. Not mind, 1, 6, 12, 13 or 28, So it's just, it's just a firmer. I suppose it's more affirmative when you can put them all together. But once you violate one, that's it. It's like mathematics in that way. But of course you have to prove it. And the proof in civil law is, within the balance of probability. So let's apply a probability here, since it's all about the balance of probability. We'll put the balance of probability to the test here from a probabilist. What about that for a novel method to determine something in civil law? Apply probability to the concept of the balance of probability. I think it's about time we had a bit more rigor in our concept of the balance of probability. Let's put it in here. So data from 31 councils and 949 councillors show a dramatic shift. In 2018, 20 councils nominated independents, 4 candidates qualified. In 2025, only 3 did. None qualified. This is an 85% collapse in independent participation. So statistical findings. Now, you see, everything in civil law is about, on the balance of probability. So let's apply probability theory to this particular event and see what the probability tells us. And then can we infer from the probability theory whether the threshold is met by the probability theory, so that we have actually a quantitative measure which supports our argument, the argument. So a 2-proportion Z-test reveals that the probability of the outcome occurring by chance is less than 0.001%. Compliance among Fine Gael councillors reached 99.6%, statistically incompatible with normal voting behaviour. The independent nomination suppression index reached 0.85, meaning an 85% suppression of democratic participation. So let's look at the constitutional implications. These results point to 5 constitutional breaches on the balance of probability. I mean, they're very high numbers. I mean, you can't contradict those statistical numbers. Article 1, sovereignty curtailed, breach. Article 6, representatives serve party, not people. That's breach. Independent, on the balance of probability using those quantitative data. Article 12, independent nomination route extinguished, breached. Breached by the quantitative analysis there on the balance of probability. I mean, like the statistics speak for themselves. I mean, we all talk about the balance of probability, but what do we mean by that? Surely we should apply some quantitative data, some quantitative methods to be able to do properly. It's been going on for years with no quantitative analysis and judgments. And I think we need to maybe put a bit more rigor into this. But let's put it in here so that we can be very, very clear that we're not that it's not subjective. Article 13, President's independence undermined, breach. Article 28, executive accountability compromised, breached on the balance of probability, as the way I'm defining it. I mean, what is the definition of balance of probability in law? I mean, surely it has something to do with probability. I mean, surely we should be a bit clearer about this, and we should give some kind of quantitative, analysis to this. Bring some rigor into this concept of the balance of probability. Very difficult for jurists, of course, but there's no jurist involved in this. So let me just be the mathematician here and the probabilist, bringing some quantitative analysis into this. A constitutional mechanism designed for pluralism was converted into a single party gatekeeping process. Now, it wasn't a single party because there was alleged silent alleged silent blocking as well. And this was alleged by Gareth Sheridan and others, publicly since then. So in 2018, 4 independents secured nominations: Mr. Sean Gallagher, Miss Joan Freeman, Mr. Peter Casey and Mr. Gavin Duffy, with cross-party support. By 2025, that route was closed. The timing and uniformity of this collapse align only with the introduction of the directive. So a High Court challenge was dismissed days before polling, and the case now lies before the Supreme Court. The issue is unprecedented. No Irish court has ever ruled on whether a party directive can amount to unconstitutional state action. So there's no precedent. I mean, just because you're as near as possible to a precedent doesn't mean it's a precedent. I mean, it's still not a precedent. So, there's all this constitutional law being cited here, there, and everywhere, by people. But no, that's just muddying the waters in terms of clarity. No, yet articles, in my opinion, articles 1, 6, 12, 13, 28 and 13 collectively require that all public officials act independently of private political control. When precedence offers no guidance, I mean, as close as you like, unfortunately, it isn't, like a mathematical convergence here. That's not it here. This is unprecedented, so there is no precedent. So this has to be all argued from what we call a mathematics first principles. So I'm even bringing the logic of calculus into this, never mind quantitative reasoning. Constitutional reasoning returns to first principles. Textual, what the Constitution says. Structural, how institutions fit together. Purposive, what the framers intended. That's the framers of the Constitution, 1937. Historical, why the provisions were created. Under all 4 approaches, coordinate party obstruction of council nominations violates the intent and balance of Article 12. This is not about one election. It's about the limits of party power in a constitutional democracy. If party executives can dictate outcomes of a constitutional process, then sovereignty no longer flows from the people, it flows from the party. I mean, this is the key issue, in my opinion. The transfer of power from the ordinary citizen, from the person, the individual citizen or voter, to the party. That's very dangerous, in my opinion. I mean, I'm not saying, it's a very dangerous precedent in a democracy that this goes unchallenged. I mean, once it happened, that if it wasn't stopped immediately, automatically, all these things were breached. So this is a very serious matter, and I'm not sure the public at large understand how serious this is in terms of the wider implications if something like this isn't challenged as soon as possible or isn't understood by the public. And this is why this is an information video, because it took me a while to put all this together, to try and see what I do to bring the mathematics and the probability experience I have into all of this. And it's very clear that on the balance of probability, however you define it, certainly if you apply mathematics or probability to it, it's a first principles argument, and secondly on the statistics that on the data analytics or the statistics that I've used here, that it's certainly on the balance of probability. There's the breaches right across the board on all of them. So one of them is enough. To contradict, to override there's a breach of the Constitution. If party executives can dictate outcomes of constitutional processes, then sovereignty, this is the point, sovereignty no longer follows from the people, it follows from the party. Now that's what you get in communism. That's unfortunately what you get in communism, and that's a really that's very, very serious. Public trust erodes, local government weakens, and constitutional independence collapses. So that's the to restore integrity. This report recommends a full constitutional review by the Attorney General Electoral Commission judicial clarification of party disciplinary limits. Now, this is before the Supreme Court, but I would say that statutory protection for councillors acting independently, publication of nomination vote data for transparency. I've done as much as I can here, and I want to dedicate this work to Mr. Niall Byrne, Mr. Maury Kenny, Mr. Walter Ryan Purcell, Mr. Peter Casey, Dr. Donica MacDown, Mr. Michael Power, and especially Mr. Gabriel Canning for their courage and integrity in defending constitutional democracy. So that's just for information purposes, because I think it's important that every citizen knows. And it took me a while to put all this together, to combine the mathematics, the calculus, in terms of the first principles, and to, you could hit this with a dozen irrelevant case laws and blind you with science with case laws, and are completely irrelevant, in my opinion. So this is a first principles case. Beautiful logic from a mathematician's point of view to start from first principles. I mean, you couldn't get cleaner, and you couldn't get stronger in terms of power. And when you apply the statistics, you couldn't get higher numbers to support the balance of probability argument. So putting all that mathematics and that probability and that first principles law together, well, I think it's a pretty clear case that it's now clear in my head that there's a serious matters here to be decided by the Supreme Court, and I just can't see any logical reason why anyone would, worded like this, find any flaw. I mean, I can't find a mathematical flaw, and I'm not. I'm pretty experienced and I know my stuff inside out. It's from a logical point of view, a legal point of view, insofar as I can see. It's completely unprecedented, and hitting it with a pile of irrelevant case law is just muddying the waters, and it's bamboozling. It's like blinding you with irrelevant science. No, we don't do that kind of thing in mathematics. Sometimes we have to start from what we call first principles in calculus, and we get the strongest proofs sometimes, and the simplest proofs, and the most powerful ones by starting from first principles.